Going to trial sounds so terrifying. If you're a party to a lawsuit and you've never been through this before, or you're an attorney and you're new and you've never been to the courthouse, or even if you've been practicing for a few years and you've never tried a case, it's understandable that you would be nervous. But believe it or not, even the most experienced trial attorneys have anxiety and get nervous about having to go to trial. One of the reasons going to trial sounds so scary is that people are afraid of the unknown. Or worse yet, they've seen movies or TV shows and they think they know what's going to happen. Going to trial is a lot of work. It's a process, and if you're prepared and you know what's going to happen, it's not scary at all. In this video, I'm going to explain to you the entire trial process, from jury selection to jury verdict. So you will have a complete understanding of what to expect if you have a case that's going to trial. Whether you are a litigant or an attorney who's going to try their first case, you will have a complete understanding of what to expect when you go to court to try your case. My name is Phil Rizzuto. I've been trying cases throughout New York City, Long Island, and Westchester for almost 30 years. I have tried civil cases, criminal cases, commercial cases, labor and employment cases. Most of what I do is personal injury, and I have tried mostly personal injury trials, both from a plaintiff's perspective, that's representing the person who was injured, and also from the defendant's perspective, which makes me unique in several ways. I have prepared cases from both perspectives, and that enables me the ability to anticipate what the other side will do, whether I'm a plaintiff or a defendant in a case. It's very fortunate to be trying cases right out of law school. Almost within weeks of starting at my firm, I was going to trial. There is no better recipe for success than preparation. Preparation, preparation, and preparation. How did I prepare? Obviously, the first thing you do is you have to review the file and become very familiar with the file, because if you don't know your file, no matter how good an attorney you are going to lose. You have to know your file. You have to know what the claims are. You have to know what your proof is that you need to do. You have to know if you're defending the case, what the plaintiff needs to prove and how you're going to refute it. You really need to know your file. After I knew my file, I would speak to other attorneys, because you can't waste another attorney's time to ask them to help you in preparing for a trial if you don't know what the case is about. Because the first questions that any good attorney is going to ask you when you're seeking advice from them is, well, what is the case about? How far away was the car, the adverse vehicle, when you first saw it? What was the speed limit? How many miles per hour was the vehicle traveling? They will want to know that specific information, and you need to know that if you are going to look to them for assistance. There are also many books on trial preparation and trial strategies, so I would review those and I would read those books. Back when I was starting out and trying cases, there was no YouTube. There was nobody on YouTube telling me, this is how you try a case and this is how a trial worked. I had the benefit. I worked with some pretty great people who would sit down with me and take time out of their day to teach me on how to try cases. And I also had the great benefit of being able to go and sit in with them on some trials and watch how they did it. That hard work, by reading books and sitting down with people, and I would say sitting down with different attorneys who were giving me advice, was probably the greatest asset that I've had in my career. The biggest benefit I had was gaining knowledge from speaking with other attorneys and being prepared. And by knowing how to prepare a case for trial, by speaking to these attorneys, by actually going out and doing that, all that hard work has served me well, because believe it or not, I have taken over cases in the middle of a trial. I just mentioned to you, before I even go into the courthouse, I have an idea of what my closing argument will be or should be. But how do I know that? Well, the very last thing the jury hears before they go and they deliberate are the judge's instructions to the jury. Okay, that is the law of the case. That is the law that they have to follow in order to come to a verdict. The judge will literally read them jury instructions taken out of this book, the New York Patent Jury Instructions. So one of the first things that you have to do as an attorney is to know what the judge is going to instruct the jurors on the case. In fact, when we open a file at the outset, one of the first things we prepare is a draft of the request to charge. And the request to charge is the specific charges in the book I just showed you that the judge is going to read to the jury. Now, this serves many purposes by knowing this. One, as a plaintiff, you need to know what you need to prove in order to be successful in your case. As a defendant, you know what level of proof the plaintiff must reach in order to be successful in their case. By knowing what the judge is going to say to the jury at the end of the case, you can use the language from those charges throughout your trial. Starting with jury selection, you should be using the words that the judge will be reading to the jury before they go and deliberate. Such things as negligence. Negligence is the failure to use reasonable care under the circumstances then and there existing at the time of the accident. So when I'm talking to a jury and I'm talking about whether it's in jury selection or on direct examination of a witness or cross-examination of a witness, I don't just use the term negligence. I use terms like reasonable. What were the circumstances then and there existing at the time of the accident? I just had a case where there was construction going on in the area and one vehicle cut off another vehicle, which was a bus. And my whole cross-examination was based upon the fact that the actions of the vehicle I represented who cut in front of the bus were reasonable because traffic was bottlenecking, traffic was merging, and it was an effective cross-examination. So much so that the bus operator admitted on my cross-examination that the actions of my driver who was merging into his lane were reasonable under the circumstances that there was construction going on in the area. Now that you know your file, and now that you know what the law is that the judge is going to be reading to the jury at the end of the case, you're ready to begin jury selection. What is jury selection? Well, most attorneys will use the phrase, it's a process by which we're looking to find fair and impartial jurors. But it's so much more than that. It's so much more than just trying to find fair and impartial jurors. Because anybody who has a bias in the case is not going to sit in the case. It is an opportunity for the attorneys to introduce themselves to the jurors. This is the first time you are meeting the jurors that will sit on your case. And you want to make a strong impression. You want to come off strong, you want to come off confident, and you want to come off like a winner. But two of the basic facts, the most basic facts that nobody ever talks about when they're talking to you about trial preparation and jury selection is one, where do you sit? That's important because you don't want to sit in the wrong seat and make it seem like you've never tried a case before. And number two, what method of jury selection are you going to use? There are different methods of jury selection. In New York County, there are three. There is White's rules, there is a struck method, and there is a strike and replace method. Most of the time, people will either use White rules or some sort of modification. If you're an experienced trial attorney and you've been doing this for a while and the other attorney's experienced, you guys can come to some sort of an agreement as to how you want to do it. How many jurors do you want to question at one time? How are you going to replace them, and so on. But you need to clarify this beforehand. You cannot start the process and then say, hey, what are the rules? I think we're doing this and you seem to be doing that. So you need to, at the outset, clarify what the rules are that you are going to use. Generally, throughout the trial in the courtroom, the plaintiff sits closest to the jury. In a jury selection room, sometimes that is not always the case because the two attorneys may be sitting side by side. The jurors are in front of you. And so when you walk in, you say, well, where you want to sit. It's generally a good way to handle it if you're not sure. But quite honestly, if you go and you sit in the wrong seat, say, oh, yeah, I didn't realize it. It's really not that big a deal. When I was trying cases as a young attorney, I never made it seem like I was inexperienced because I didn't want the other attorneys to think they could take advantage of me. I always portrayed like I had experience and I knew what I was doing. But sometimes it's okay to let them know that you don't have the experience because they'll be a little nicer to you and they'll be a little more forgiving. And believe it or not, some attorneys, your adversaries, may actually try to help. If now you have 15, 20, 30 jurors in a room, Who do you question? You don't question them all at once, although sometimes you actually do. Sometimes I actually have. We've questioned all the jurors at once. But most of the time, you're only going to question 6 at a time. We refer to them as the first 6. So you have these jurors in a room, they hand you these cards with their names on them, and the dates of last jury selection, and I think kind of where they live, and you have these cards, and there is a bin. There's like a metal round bin, like from medieval times, like where you play bingo, and you put the cards in a bin. Usually a court officer will come in. If a court officer is not available, the attorneys will circle the bin and the names will be drawn out. Who does it? Well, usually it's the plaintiff attorney. That's the person representing the parties who bring the lawsuit. Sometimes the one attorney will draw the card, the other attorney will call the name. Nobody likes to call the name because they don't like to mispronounce the names, especially in New York, where we have such a diverse population in New York City. When the names are called, again, usually all the seats are filled. So people in the first 6 seats generally have to get up. They stand to the side. The people whose names are called get filled into the seat. That's another thing. You have to know which end is seat number 1. All right, is it on the left or is it on the right? Because when you are questioning the jurors, how I do it is I have a legal pad, a yellow pad, and I write down the jurors' names. I like one being on the left because it's easier. So I go 1, 2, 3, 4, 5, 6, and I put lines on the paper, and I can make my notes. So, but you want to agree on, who juror number 1 is. Some people want to do it from right to left. It depends, but you definitely want to know that beforehand. So the names are called and they get seated, and then the plaintiff's attorney will say, "Can you please hand up your questionnaires?" What are the questionnaires? The questionnaires are documents that the jurors are given when they come in at first to serve jury selection, and they fill out their personal information, such as their name, where they're living, not their actual address, but the country or the city where they were born or the state where they were born. Who else is in the household? What are the occupations of the people in the household? What are your hobbies? Have you ever served on jury selection before? Have you ever been convicted of a crime? Now, these are all questions that go on the questionnaire to try and make the jury selection process go faster, so you don't have to answer the questions. I personally don't think it makes it go faster because once we get the questionnaires, they have to be separated. There is a white, yellow, and pink copy. So usually they have to get separated. The copies, the pink and the yellow copies, are usually not that legible. So usually one attorney will rip them off, the other attorney will separate them and kind of put them in order. And once you have the questionnaires, the plaintiff's attorney will tell the jurors, "All right, give us a few minutes to look at them." And the 2 attorneys look down and we're writing, and we try and get as much information from the sheets onto our pad. But quite frankly, personally, I don't like to do that. I don't like to sit there and have the jurors seeing me ignore them and writing. The information is on the paper. That's how I feel. I am going to ask the questions anyway. If I'm a plaintiff, I'm going to get the information out. And if I'm a defendant, I have the opportunity to sit there while the plaintiff is questioning the jurors and take down my notes. So it doesn't look like I am ignoring them. They're not paying attention to me anyway when the plaintiff is speaking. So that is an opportunity for me to write down the relevant information. But if I'm the plaintiff on the case, I don't like to do that either. I like to get right into it. I don't like the jurors to think I'm wasting their time or I'm ignoring them, and I want to interact with them, and I want to engage them. I want to get them engaged right away. Because if you're looking at the papers and you're writing down notes on your legal pad, the jurors are just sitting there and looking at you. All right, so now we've looked at the questionnaires and we've taken our time and we've studied them and we've prepared our notes. And now it is the plaintiff's opportunity to speak. Generally, the plaintiff will introduce themselves. They'll say who they represent. They'll introduce the parties. Sometimes this is even done before we seat the jurors or before we take their questionnaires. That's generally one of the first things that the plaintiff's attorney will do. And most often than not, they will let the defense attorneys then speak and say who they are and who they represent. The reason the plaintiff is taking the lead in this and the plaintiff is going first is because the plaintiff goes first throughout the trial, pretty much because they have the burden of proof. So the plaintiff gets to speak to the jurors first in jury selection. They get to speak to them first during their trial. They do their opening statement first, and they put on their case first. They do their direct examination first. The defendants don't really have to do anything. They can do a cross-examination if they want. When the plaintiff rests, the defense can put on a case. But the whole process is designed like this because the plaintiff has the burden of proof. It's not through any random acts. It's not through rock, paper, scissors. It's not through flipping a coin. Because the plaintiff has the burden of proof, they go first throughout the trial, except when it comes to the closing statements. They get to speak during the closing statement. So the plaintiff gets the first word and they get the last word. And if you're a defense attorney, you need to address this, and you need to address it at the outset in jury selection. So now the plaintiff's attorney will start by speaking to the first 6 jurors in general. They will tell the rest of the room, hey, rest of the room, pay attention, because at some point you're going to be in these seats. If you can anticipate the questions, you know what we're looking for, it makes the process go that much faster. And it does. It does. Maybe they start with some general questions, an idea about what's going to happen during the case, an idea about what the case is about, try and get some sort of an idea as to what's going to happen, and to get some sort of feel as to whether or not anybody has a bias or cannot sit on this case for whatever reason. Medical issues. They have a vacation scheduled. They're a student and they're in school. Believe it or not, the students are called, and they shouldn't be, especially during the school year. And I told you the questionnaires have some very personal questions on there. Whether you've been convicted of a crime, whether you know anybody who's been injured or has had a lawsuit. These are things we need to get into with the jurors. So the plaintiff's attorney should, at the outset, tell the jurors, we are going to be asking you some personal questions. These are not made to make you feel uncomfortable, but we have to find out this information to see if this is the type of case that you can sit on. Again, a lot of people use the term fair and impartial. I think it's a little corny and overplayed. I don't like to use those words if I don't have to, but that's the catchphrase. We're looking for 6 juries and usually 2 alternates who could be fair and impartial, meaning they have no bias. So the plaintiff's attorney should, at the outset, in speaking to the jurors, let them know, hey, we're going to be asking you some personal questions. If you're uncomfortable, we can speak outside. And many jurors take advantage of that. If during the questioning, either side, either the plaintiff's attorney or the defendant's attorney, says anything that is objectionable, do not fight in front of the jurors. You go to the other attorney, you say, hey, can we speak outside? That's the best way to handle it, because you don't want to have the jurors see you arguing, especially in jury selection. You don't want them to see you nitpicking, and the other attorney's not always going to agree. And if you don't agree, then you have to go find a judge to get a ruling on what the issue is. There are times where somebody will say something inappropriate during jury selection that can cause the whole panel to be busted, and you have to start all over with a whole new panel. So you want to be careful about what you say. You are really limited to the facts of the case. You can't talk too much about the evidence. You are really there only supposed to be probing as to whether or not these people are a good fit for your particular case, or whether they're not a good fit. Once the plaintiff's attorney finishes with the general questions, he will speak to each juror individually and ask them personal information. If there is a check on the box that they've had prior jury selection, he may ask them about that. You cannot ask what the outcome was, but you can ask them how they felt about the experience. Were they satisfied? Were they dissatisfied? And by doing that, you can kind of gauge in a lot of situations what the outcome is and what type of juror they are. Sometimes they'll say, oh yeah, we didn't believe the plaintiff, we dismissed the case. Well, as a defendant, you want to get the juror on the case. And as a plaintiff, you don't want that juror on a case. And sometimes they'll be like, oh yeah, we awarded a lot of money, and vice versa. The plaintiff will want that person on the case, and the defendant may not. The facts of each case are case specific. So the indication that a juror dismissed a case or awarded a lot of money on a prior case really should not have a bearing on your particular case. because the facts of your case may be different, and you cannot really get that much information out of them. You can find out if it was a civil case, if it was a criminal case, if it was a personal injury case, if it was a commercial case. You really cannot get that much information out of them. If they've ever been convicted of a crime. A lot of times the attorneys will say, can we step outside? Or you want to step outside to talk about this? Some cases, especially involving significant injuries or even death, the jurors break down crying and they say, I can't talk about this. Can we step outside? And they'll tell you that they had a similar experience or somebody in their family had an experience, and they cannot sit during this trial. And usually the attorneys will agree. But once the plaintiff's attorney questions all 6 jurors individually, and he is satisfied and he has no more questions, then the defendant's attorney gets an opportunity to get up and speak to the jurors. Usually the defendant's attorney, if the plaintiff doesn't do it, should offer the jurors a break to stretch, go to the restroom, get a drink, whatever it is. If I am defending a case, it's the first thing I will ask the jurors. I've tried cases as both a plaintiff and as a defendant. The manner in which I do jury selection is pretty much the same no matter which side I represent. If I'm a plaintiff, I will go more in depth and I will speak longer and I will cover more things. And this is for 2 reasons. One, if I cover a lot of the things that the defendant is going to cover, it takes the wind out of their sails. And I have the ability to do that because I have tried a lot of cases as a defendant, so I know the things defense attorneys are going to say. So if I address it first, then I am taking the wind out of their sails. The second reason is, quite frankly, it's easier for me. It's easier for me to have one format than to adjust my format depending on who I represent. I have a pretty good format. Usually there are 3 categories, 3 main questions that I will ask the jurors. And if I am defending the case, I really do try to limit it to these 3 areas because I don't want to bore the jurors. I don't want to have them disengaged. The first question I will always ask them is, can you keep an open mind? Now, I handle it differently as a plaintiff than I do as a defendant, as a defense attorney. The reason I need to ask that question is because as a defendant, I go last, I go second throughout the whole trial. So if they don't keep an open mind, I'm going to lose the case. Right? And I tell them that. But I don't tell them like I'm telling you. So first thing I do when I start out is I will tell them, if I'm a defendant, I represent the defendant, and we claim that the plaintiff was not injured as a result of this accident. If I'm the plaintiff, I will tell them I represent the plaintiff. Usually refer to the parties by their name. You don't want to make it impersonal. Always refer to the parties by their actual name. And we're making a claim that Mr. Plaintiff sustained significant, severe, and permanent injuries as a result of the defendant's negligence. And this is why. As a defendant, we take a different position. If the person was injured, sometimes I will say we're not disputing the fact that the plaintiff was injured. We have a dispute as to the valuation of the injuries if liability is not in dispute. Or sometimes I will tell them this accident was not my client's fault. So depending on who I represent will depend on how I handle it. But when it comes to can you keep an open mind, I will say to the jurors, why do you think it's important for you to keep an open mind? And I get a discussion going. And they will tell me. Usually they all touch upon it. Some hit it right on the head, but they all sort of touch upon why it's important to keep an open mind. And after we have a discussion for a few minutes, I will say yes, because I go last throughout the trial. I explain to them the trial process, and I tell them if you don't keep an open mind, I am going to lose the case. And they all promise me that they will keep an open mind. The second thing is, will you follow the law? And I usually add, even if you disagree with it. Now, again, it's a little different if you're a plaintiff or a defendant. I go into it in a little differently. But regardless, I will start off with, why do you think it's important to follow the law? And you'll get all sorts of different answers from the jurors, and all of them are partially right. And quite frankly, even if they're not right, you tell them that's a good answer. And in the end, you tell them why it's important to follow the law. And the reason it's important to follow the law is if you don't follow the law, right, it's not fair to either the plaintiff or the defendant. You think what the law is, you're going to do what you think the law is or what you think is right. But in New York State, you have to sustain a certain level of injury, a serious injury as defined under the law, in order to recover for pain and suffering. And some jurors do not believe that. They think if you're in a car accident, you get treatment, you should be compensated. And that is not fair to a defendant who may have a valid defense in that situation. As a plaintiff, you don't want them holding you to a higher burden of proof than what is required. So if you meet that serious injury threshold, the jury should award your clients fairly and compensate them justly because you have met your burden of proof, not because they think you need to do more. And there are different standards as to what the plaintiff must prove. The defendant doesn't really have to prove anything unless there's a counterclaim or something to that effect. But that is all part of the instructions that the judge will read to the jury. So it is very important for the jurors to follow the law, but you don't just ask them, hey, will you follow the law? Or tell them, hey, you have to follow the law. You kind of have to engage them and have a discussion with them as to why it is important. And I have found that to be very, very successful by doing that. The third and probably one of the most important categories is, again, will you hold the plaintiff to their burden of proof? Again, as a plaintiff, I address it because I know the defense attorney is going to address it. And if I'm the defense attorney, I harp on it. And I will tell the jurors at the outset, you're going to hear me say the burden of proof so many times, you're going to have a game going on in the back doing it over and under on how many times I mention burden of proof. So as a plaintiff, and most good plaintiffs' attorneys will address this at the outset and say, hey, I have to prove my case, right? And in jury selection, you have to be kind of careful as to what you're going to tell them. But you have to be confident. You say, you know what, I know I'm going to have to prove my case to you, and I'm going to do it. And sometimes you try to get from the jurors what sort of proof are you expecting to see during the trial, and that's sort of helpful. It's kind of objectionable, but you kind of have to, if you're a defense attorney, you kind of have to see how far the plaintiff's attorney is going to go with it. But as a plaintiff's attorney, you have to bring up burden of proof because the defendant's attorney is certainly going to do it. And if you are the defendant's attorney, that is your hammer. That is your hammer. That is your hammer. You have to keep mentioning burden of proof throughout the trial because the jurors have to know that this is not the lottery. This is not a free-for-all. That plaintiff is entitled to fair and reasonable compensation. And I will say that as a defendant. Okay, the plaintiff is entitled to fair and reasonable compensation if you find that they meet their burden of proof. And they are. I don't say it just to say it, but the law is what the law is. And the jurors have to do that. You want them to follow the law. You want them to hold the plaintiff to their burden of proof. And that's why I go through the exercise and having the discussion with them. And when we go through the process, I will talk to them generally. I talk to them generally at first with the 3 questions, and I'll go around and try and engage them and get different answers from different people. And if they don't answer, and that's common, I will call on them. I'll say, what do you think? Why do you think it's important to hold the plaintiffs to their burden of proof? Why do you think it's important for me to be able to prove my case? One of the reasons you tell them is because anybody can just go and file a lawsuit. You don't have to prove anything to go file a lawsuit. Anybody can just do it. And it is not fair to somebody who is being sued to have to pay for something they didn't do, or because the plaintiff cannot meet their burden of proof. Have you ever been blamed for something you didn't do? And how does it make you feel? That is what I will bring up to the jurors if I am defending the case, because you want them to relate to the defendant if you are defending the case. Again, I just tried a case where an accident occurred. My client hit a man on a motorcycle and the man lost his leg. There was no dispute that it was my client's fault. There was no dispute that this man was entitled to compensation. There was a dispute as to the value. And the plaintiff's attorney had suggested a value of almost $27 million. My evaluation came in a little bit under 2. I think it was under 1.5, around 1.5. And the jury came back with a $3 million verdict in total. Now, the plaintiff's attorney has spoken to the jurors, the defense attorney has spoken to the jurors, and they have asked them the individual questions. Now what? Now what do you do? Well, some plaintiff's attorneys will be like, I have more questions. No. Once the plaintiff's attorney sits down, they are not allowed to ask any more questions. Sometimes they will ask in front of the jury, the other attorney, I just have a few questions, do you mind? And the defense attorney has to respond yes or no. Technically, they're not allowed to. Sometimes it's allowed. Sometimes the attorney will be like, nope, you've asked your question, you don't have an opportunity to do it again, and let's go outside. So at that point, it's a good time for the jurors to take a break, and you tell the jurors, we are going to go outside and talk and take a break. The attorneys leave the room, they go someplace out of earsight or eyesight of the jurors, and they will discuss who is going to be on the jury and who is not going to be on the jury. And the first thing the parties agree to is, well, do we have any for cause? What does cause mean? Cause is what I sort of alluded to earlier, where somebody has a bias. They've had a similar lawsuit. They tell you they are favoring one side over the other side. It's not a good case for them. Having child care issues or medical issues is not necessarily a reason for cause, but there are specific laws which state why when people are exempt. If you work for an insurance company and it's a personal injury claim, you cannot be on a jury. So you have to look at what the requirements are to be on a jury and not be on a jury, and you have to have some sort of a feel with your adversary as to what's right and what's wrong. Sometimes the attorneys agree, and sometimes the attorneys do not agree. If you don't agree, you have the option again. You can go to the judge for a ruling and say, this is what this juror said. He shouldn't be on the jury, or he should be on the jury. And a lot of times the judge will say, all right, let me speak to the jury. So you got to go back. You got to get that juror. You got to bring that juror to the judge, and the judge will question them. And the judge will make a determination. Can this person sit on the jury, or can this person not sit on the jury? And you kind of have to live with the ruling. If you do not want the person on the jury and the judge says, they're not off for cause, you can use a challenge, a peremptory we call it, and you can take that person off for your own reasons. You cannot take a person off a jury based upon their race. That's called, there's a famous case known as Batson. It's known as a Batson challenge. If you take a juror off solely because of their race, the other attorney can say, no, you can't do that. You have to have some sort of justification for taking them off. Now, once you've decided what jurors are off for cause, the plaintiff goes first, and the plaintiff gets to exercise their challenges. And the reason the plaintiff goes first, again, is because the plaintiff has their burden of proof. Now, under White's rules, again, which is the most common, and even under the other methods, the rule is usually alternately and singularly in a round. Generally, you get 3 challenges per side in New York. If there are multiple defendants, you have to hash it out beforehand, because a lot of times the plaintiff will get 3, the defendants may have to share 3. If there are conflicting interests between the defendants, either you work it out amongst yourselves, or you go to a judge, and the judge will make a decision as to how many challenges each side gets. Usually, if the defendants get their own challenges, the plaintiff will get as many challenges as the defendants have combined. So sometimes the defendants will get 2 and 2, and the plaintiff will get 4 challenges. So alternately and singularly means that if the plaintiff exercises a challenge, whether the plaintiff does or he doesn't, that the defendant does or he doesn't, the plaintiff gets a board back and can exercise another challenge. If the plaintiff does not exercise a challenge and the defendant does or does not, the plaintiff cannot come back and say, oh, you know what, now I want to take off juror number 1. You have to do it. You don't necessarily have to do it in order of where the jurors are sitting. You can take off juror number 6 and go to the other side, get the board back, and then you take off juror number 2. So you do not have to do it in order, but in order to exercise multiple challenges in a round, you have to take your challenge in the first round. Once this is done, once we say the round is complete, the attorneys go back into the jury room. They tell the jurors, all right, we're going to tell you who's been selected for the jury and who has not been. Usually you take the names of who has not been first, you give them their card back, you give them their questionnaire back, and you tell them to go back to wherever they came. Again, before COVID, it was known as central jury, and you tell them to go back to there and tell them, wait to be called for another case. The jurors that have been selected, you take their card, you put it in the board, and you tell them to go sit outside. Sometimes there are other requirements that the court may tell you. Generally speaking, you get those out of the room. You call up 6 more people. The process starts again. The plaintiff speaks first, then the defendant speaks. When everybody is done questioning the jurors, the parties go out and exercise their round. In the next round, the defendant gets to exercise their challenges first, then the plaintiff goes, and the process repeats until you have a full jury. Once you have a full jury, you are now ready to begin your trial. Now, you may or may not have been assigned a judge at this point. Generally speaking, you have to let whoever it is that you report to, whether it is a jury clerk, and again, different counties operate differently. But if you have already been assigned to a judge, the judge will give you your instructions, and you have to let the judge know, we have finished jury selection, we're ready to start the trial. If you haven't been assigned to a judge, you go back to the jury clerk and say, hey, we completed jury selection, when do we get a judge? Sometimes they will say, go to Judge so-and-so. Sometimes they will say, let me see who's available, and they will start making phone calls. Sometimes they will say, come back tomorrow, or we will give you a call when we have a judge available. Different counties work differently. If you haven't been assigned a judge at this point, you will be. Now you've been assigned a judge. What do? Well, you go to see the judge. You go to the judge's courtroom. One of the first things the court clerk is going to do is ask the plaintiff for marked pleadings. Marked pleadings is the complaint that the plaintiff files to start the lawsuit that are actually marked up to show what the defendant's answers are to the complaints. There are usually 3 types of answers. There are a few more, but the 3 most common are admit, deny, or deny knowledge and information sufficient to form an answer, or belief to form an answer, and they are usually initialed something like this. So if you see here, in this case, there are DKI, admit, DKI, DKI. There are denials, other places on the complaint, but for our purposes, I just want to show you an example of what a marked pleading is. Now, a good attorney will hand in more than what I just showed you. Generally, when I go to court and I am the plaintiff, I will prepare my marked pleadings like that, but I will add the important documents that I want the judge to see. So if I have photographs that are helpful, I include it. If there is a police report that is helpful, I include it. If there are medical records or medical reports that are helpful, I include that in my marked pleadings in either some sort of a loose leaf binder or as a binder clip, so the judge has everything in front of him. The other things I will include in the marked pleadings are the copies of the deposition transcripts. Why? Because during the course of the trial, you're going to refer to the deposition transcripts, probably to impeach witnesses, and you want to have, and the judge will need a copy. So if you hand it up to him in advance, he has everything he needs. You look professional, you look prepared, and you make a favorable first impression when you get before that judge. The clerk then brings the marked pleading back to the judge. The judge reads and learns a little bit about the case while you're in the courtroom waiting for him, and then you will be asked to see the judge. The other thing the clerk will ask you is for your business cards and who you represent. So they have all that information up front. So both the plaintiff and the defense attorneys will need to have business cards, so they can give it to the clerk so they know who to contact with respect to this case. They should also give you the courtroom phone number so you know how to contact the court in the event there's a problem. What problem? You could be running late. You can get sick. Any sort of thing that you need to contact the court for, especially if you're running late, but don't be late be early, but sometimes things do happen and you need to contact the court. So you exchange the information, you give the clerk the mock pleadings, the judge reviews the mock pleadings. The judge, when he's ready, will call the parties in to talk to you about the case. What's he want to talk about? We're ready to try the case. Well, the judge will always make an attempt to settle the case. 99% of the judges will make an attempt to settle the case. There are a few judges that will make no attempt. They'll say, you're ready to go, let's go. Most judges will try to settle the case. They'll see if the case can be settled, and they will talk about trial scheduling. Judges have lives too. They have schedules. Some judges have motions on certain days. Some judges have other commitments doing other things within the courthouse. And there are certain days that they can't work. So you want to talk about scheduling. That is important because you need to know when to bring in the witnesses. To me, that is the most difficult part of the trial, is making sure your witnesses are available, making sure they're ready, and they're ready when the court needs them ready and when you need them ready. And doctors, paid experts, they're the most difficult. Some of them you have to book in advance. Some of them sometimes you have to go to the judge and say, Judge, my doctor is only available on Friday and I've already paid him. If the judge is not available on Friday, you're screwed. You need to get the doctor to work with you. Some judges will actually help you and make a call. We had a situation last March where the judge canceled court because of the weather forecast. Turned out the weather wasn't so bad, and that was the day the plaintiff's doctor was supposed to come in. So kind of be mindful of that when you're scheduling your doctors, especially if you have to pay them in advance, or any expert that you have to pay. But you have to discuss scheduling, and the judge will make an attempt to settle the case. One of the things I learned very early on is, as a plaintiff, you have to be ready to start the case. As a defendant, you can buy some time. But if you're the plaintiff's attorney, you're representing the plaintiff, you have to be ready to go from start to finish. So you conference the case, you decide when you're going to start, and then you come in and you start your case. So how does the trial process work? What is going to happen? The first thing that happens is the judge will instruct the jury. They call them preliminary instructions. Again, they come out of this book, the New York Patent Jury Instructions. These are charges that come out of the book for the beginning of the case. Once the judge does his preliminary instructions, we're ready to go. Plaintiff, are you ready to give your opening statement? Yes, sir. Plaintiff gets up. Usually they start with, thank you, Judge. May it please the court, opposing counsel, members of the jury, and they go right into it. You want to make a strong opening statement as the plaintiff. You need to tell the jury what this case is about and what you are going to prove. It is like a table of contents. You have to lay out your case. If you do not lay out the foundation of making a case, the other attorney can make a motion to dismiss your case just based upon your opening because you did not tell the jury what you're going to prove. Have I ever seen it done? Has anybody ever actually lost a case because of it? I don't think so. I don't recall, but it can happen. And if you get a judge who wants to get rid of the case, they can probably do that. If you don't tell the jury what you're going to prove and how you're going to do that. This is much different than opening statements. You need to get into what you're going to prove, who your witnesses are, what your witnesses are going to say, and the other evidence you're going to show them. Now, that being said, don't make promises you can't keep. Do not make promises you can't keep. Everything you do, you're being judged on. Your credibility will win or lose you the case. So if, as a plaintiff attorney, we never, ever, ever want to make a promise that we can't keep. So if you're telling the jury this is what you're going to do, you better be able to do it. Now, a defense attorney, after the plaintiff finishes his opening statement, the defense attorney gets to give an opening statement. The defense attorney has two options. The defense attorney can take a very laid-back approach and say, listen, you heard the plaintiff say what he's going to prove. Let's see, let's wait and see what the proof is. At the end of the case, I'm going to ask you to do this. And basically keep it very simple and non-committal. Why? Sometimes because you don't know what the plaintiff's going to prove. You should, but sometimes you really don't know how the evidence is going to play out. Sometimes there are things that may or may not come into evidence that can make or break the case. So if you are the defendant, you want to kind of play it loose, say, all right, let's wait and see what happens. You'll have plenty of opportunities to show your trial skills. And sometimes some of the most important trial skills are sitting back and not doing anything. Another way to handle it is take a strong position in your opening statement and tell the jury what this case is about and why they should find in your favor, and you tell them the evidence that they're going to see. And if you know that the plaintiff is already lying to them, you call the plaintiff out on that in your opening statement. You be strong, you be powerful, you be confident, and you can take that position. And by doing that, you are already getting the jury thinking, hey, you know what? He said this case is a fraud. In the back of their mind, while this is going on, they're going to be looking for evidence that this case may be a fraud. Everything you say and everything you do throughout the trial should be calculated. It should serve a purpose. You don't say things unless they serve a purpose. And you need to know that from jury selection, from your openings. Also in your openings, as a plaintiff or as a defendant, use the words as a charge. The evidence is going to show that Mr. Plaintiff, who I represent, was operating his vehicle on Main Street on June 25th of 2017, and he was operating his vehicle in a reasonably prudent manner. He was seeing what was there to be seen at the time, and then he saw the other vehicle go through a red light without any warning. Those are words from the jury charges. Reasonably prudent person, under the circumstances, seeing what is there to be seen. Those are words that the judge is going to read the jury at the end of the case, and you want to use them in your opening statement. Not only do you want to use them in your opening statement, you want to use them throughout the trial. You want to use them in your direct examination, in your cross-examination, and in your summation. You want to consistently use the words that the judge is going to read the jury throughout the trial. After the openings, the judge will turn to the plaintiff and say, Plaintiff's counsel, are you ready to proceed? Yes, sir, I am. Call your first witness. And they will call their first witness. Plaintiff's attorney has an opportunity, not an opportunity, they have an obligation because they have to prove their case. They will do what's called a direct examination. They will ask their client or whoever their witness is. It's not always the client that is the first witness, believe it or not. Sometimes the plaintiff will subpoena the defendant, and the defendant will be the first witness. So it's not always the plaintiff that is the first witness, but whoever the first witness is. Now, if it is the adverse party, sometimes the judge will give the plaintiff's attorney permission to treat the witness as hostile, and he can question that witness with leading questions as if they were doing a cross-examination. But if the witness is not treated as a hostile witness, and it is the plaintiff's witness or your witness on direct examination, you have to ask open-ended questions. What are open-ended questions? Who, what, where, when, why, and how? Those are open-ended questions. A question that, didn't you come to the courthouse today in a bus, is not an open-ended question. That is a leading question. You are feeding the answer to the witness, and that is a leading question. That is appropriate for cross-examination. That is appropriate for a hostile witness. That is not appropriate for direct examination. You must ask open-ended questions on your direct examination. Once you finish your direct examination, the other side, the defendant, has an opportunity to do a cross-examination. Now, because the defendant doesn't have the burden of proof, the defendant does not have to do a cross-examination. They can say, I have no questions. Most attorneys will do a cross-examination. Your cross-examination has to be consistent with your theme of the case. Your cross-examination has to serve a purpose on what you are trying to prove. Your cross-examination has to be organized. It has to be thought out. You cannot just go up there, or you can just go up there, but it will not be effective and ask random questions. You have to have a plan in cross-examination. It has to be consistent with your theme of the case. You can feed the witness. You should be feeding the witness on cross-examinations to the answer you want to get. You want to get to point D, you got to go through A, B, C first to get there. And there is a method, there is a methodical method to doing that. Don't ever, ask a question you don't know the answer to, unless there is no wrong answer. Whatever the answer the person gives is a good answer for you, or that no matter what the answer is, cannot hurt you. But your questions have to be calculated, and I do not recommend reading your questions. I do recommend being prepared for your cross-examination, having an outline of your cross-examination. But if you read off a script, you're not going to do an effective cross-examination, because you have to adapt to what the witness says. You have to be prepared, even if you anticipate what the answer is, because I said, remember, always ask a question, you know what the answer is. Sometimes you get an unexpected answer, you have to be able to adapt. And it's not always going to go the way you plan it. So if you're reading off a script, you're going to miss something very, very important. So you need to have an outline, you need to know the areas you want to cover, you need to have items cross-referenced so you can impeach the witness with inconsistent answers and know where their previous answer was that was inconsistent. You need to have that information available. You need to have it in notes forms, or if you're really smart, remember it and know where to go with it. But during any course of the process, I don't recommend reading. I've seen people read their questions in jury selection. Don't do it. I've seen people read their opening statements, their closing statements. Do not do it. It is ineffective. You are better off having notes, having an outline, doing your presentation, doing your questioning off the cuff. You can always take time to Judge, can I take a moment to review my notes? Make sure you cover everything. You can always do that, and nobody really cares. But if you read it, you're not doing yourself justice. You're not doing your client justice. You need to be prepared. You need to know where everything is. You need to make sure you cover everything. But reading it, don't do it. Now, after cross-examination, the plaintiff's attorney had an opportunity to do what's called a redirect. They can only ask questions that were raised on cross-examination that were not brought up during the direct examination. Once that's done, the plaintiff can do recross on new questions, and you can go back and forth till either the judge tells you, all right, no more questions, or you covered everything. But on redirect and recross, you can only bring up questions that were raised that were new matters. Very, very important. Very important. During the plaintiff's case, you need to put in whatever the evidence is that you want to get put in, and how you do it depends on the type of evidence. It depends on the judge. It depends on the adversary. Some judges will say, what evidence can we stipulate to beforehand? Sometimes the parties agree to everything, sometimes not. Sometimes you do it as you go. When you question the witnesses, you mark something for ID and then you offer it into evidence. And if it doesn't get in, it's still marked for ID, but it's not in evidence. But if you do not get in what you need to in evidence on your direct case, you're not getting it in. You will not get it in afterwards. So make sure you know what evidence you want, make sure you know how you're going to get it in, and make sure it is in before you rest. Because after you put on your witnesses, you put in your evidence, at some point there is no more. And you will have to rest your case as the plaintiff. And you've heard the expression, plaintiff rest. Okay, plaintiff rest. Now what? Well, the plaintiff will make a motion, what's called for a directed verdict, which basically says, Judge, I've put in my case, this is why I should win. Let's not even hear what the defendant has to say. I win my case, and this is why. Please tell me I win my case. That's usually a very tough sell, because the judge will most likely want to hear what the defendant has to say. They'll hear what their position is, and that's something that is not ever granted at that point. But the defendant must also make a motion. The defendant has to make a motion to dismiss based upon the plaintiff's failure to prove a prima facie case. What does that mean? There are certain elements that the plaintiff must prove in order to get to a jury. If the plaintiff does not prove it, the judge has the power to dismiss the case right then and there. Now, this is different from the plaintiff's motion, because we've already heard the plaintiff's case, and the defendant does not have to do anything. So the judge can make a decision, say, hey, your case is not going to the jury. If it's a close call, the judge may reserve decision. reason he reserves decision is, you know what, let's see if the jury does the right thing. If the jury doesn't do the right thing, I still am reserving my authority to dismiss this case if I deem fit after everything is said and done. So if the judge reserves decision, that means if the jury doesn't dismiss it, he still may be able to dismiss it. So the motions are made. Also, before you make these motions, you're going to do them in every case. You're going to do them in every case. So what should you do before you make the motion? Have a memorandum of law. Have a memorandum of law available if there are exhibits. Sometimes, in certain situations, it behooves the attorney to order a copy of the court transcripts. They call them dailies. The court reporter is there, everything's on the record. You can order the transcript at the end of every day, and you can use that to make a memorandum of law as to why the case should be, either your case should be given a directed verdict or why the case should be dismissed. And this is powerful because now it's in writing, you have it before the judge, the document is marked as a court exhibit, and it is much more compelling for the judge to grant it if he sees the information right before him. Most of these motions are done as a matter of course, as a matter of fact, they're formalities, but sometimes they are warranted and sometimes they are granted, and you want to maximize your chance of winning. And to maximize your chance by winning, be prepared, have the motion, have it marked as a court exhibit. And then this becomes an appealable thing if the judge doesn't do what should be done and the jury doesn't do what should be done. You know, if there are mistakes made and the decision is wrong, or you think the decision is wrong, you have the right to appeal it. But in order to appeal and to be successful, you have to make sure the record is protected, and you ask for these things. You ask for the motion to dismiss, and you have valid reasons for it. You cannot just say, Judge, give me a directed verdict. Now the defendant has the option to put on a case if they choose. Same thing goes for the defendant as for the plaintiff. Now, the defendant has one little advantage that the plaintiff's attorney doesn't, because the plaintiff can get items into evidence on the plaintiff's case by various methods, either through a witness or they stipulate to it, but there are ways to get what you need into evidence on the plaintiff's case. And if you didn't get it in on the plaintiff's case, you can get it in on your case. But you have to know what you want in evidence, and you have to know how you're going to get it into evidence. It is not a given. You need to know how you're going to get what you need into evidence. So you have to have a plan. You can call witnesses or not call witnesses, but if you want something in evidence, whether it's testimony, photographs, record, whatever it is, you need to have a plan, and now is your opportunity to do it. Again, the process is the same. If you call a witness, the defendant does a direct examination first. The plaintiff has an opportunity to cross. Then there's redirect, recross until all the witnesses are called, all the evidence is in, then the defense rests. Then, guess what? Both sides make their motions again. Now, the plaintiff's motion for a directed verdict now is a little more compelling because that the judge has had an opportunity to hear what the defendant has to say. Right? And the motion is made to the defendant, not the jury. The jury will render a verdict if they get the case, if they get to make a decision on the case. So these motions are made to the judge outside of the presence of the jury. Again, it's better to have a memorandum of law. If you already had a memorandum of law, you can update it. You can order the dailies, and now you have additional information, and you can update your memorandum of law and submit a new memorandum of law and have a new court exhibit. If the judge denies it, the judge has three options. He can grant it, he can deny it, he can reserve decision. Those are the three things the judge can do. If he grants it, the case is over for now. The losing party then can appeal it, but the jury is disbanded, everybody goes home. If he denies it, then the case goes to the jury, and the jury gets to decide the case. And if he reserves decision, the jury gets to decide the case, and the judge can overturn the jury verdict. So this is what happens on these motions. So now the plaintiff put on their case, the defendant put on their case. All the motions are made. Now you have the closing statement. Closing statements are the opportunities for the parties to sum up the evidence. Now you've heard it all. And the parties now can spin the evidence in the light that's most favorable to them. And I've seen it done. I mean, I had a case where there was a video of the accident, and there were 3 different attorneys who put 3 different spins on how this accident occurred and who was at fault for the accident. And this is what you can do in your summations. So you want to summarize what the jury just heard. You want to use the words of the law in your summation. You want to provide clear and convincing evidence as to why the jury should find in your favor. And you really want to be powerful, and you want to be persuasive. Don't read your summation. Make notes, make an outline, but I encourage you not to read your summation. I encourage you to be passionate, to be powerful, and to tell the jury in a reasonable, concise manner as to why the evidence favors you and why they should rule in your favor. Last thing in the case, before the jury gets it, is the judge will read the jury the law, right? And again, the law comes from this book, the New York Patent Jury Instruction. So the judge will read the law. The judge will be telling the jury everything you should have been telling them throughout the trial. Again, if it's negligence, so use terms like prudent, reasonably prudent, see what's there to be seen. If it's a motor vehicle accident, reasonable care, a preponderance of the evidence. You know, in a criminal case, the burden of proof is beyond the reasonable doubt. But these are the things you need to know. Preponderance of the evidence is more likely than not. So in your summation, if you're the plaintiff, we want to say, you have to be careful, because this could be objectionable. If the judge is going to tell you the law is that burden of proof is preponderance of the evidence, and it means more likely, you can be objected to, and technically the objection should be sustained. But what you can say is, you've heard all the evidence. It is very clear that it is more likely than not that this accident was the fault of the defendant. And these are the reasons why, and you can go into that. But you want to use the words of the charge throughout the trial. I keep telling you, if there's one thing you take away from this video, that is to do your jury charges first, use the words of the law throughout the trial, starting with jury selection. I cannot emphasize that enough. Now the jury is going to read these charges to the jury. It usually takes about 45 minutes to an hour, depending on the case and how many pages he has to read. And they lock the courtroom. Nobody is coming in or out of this courtroom for any reason. If you have to go to the bathroom, you better hold it or have a Coke bottle, because that's not happening until the charges get read. So the courtroom is locked. The judge reads the charges to the jury, and when he's done, the jury goes and deliberates. First thing the jury is told to do when they go into deliberation is to pick a foreperson. Usually it is juror number 1, but it's not always number 1. The foreperson is responsible for sort of coordinating the jury, getting their questions together, sending the note to the court if there is one. And during the course of jury deliberations, the juries may have questions. So how do they get their questions answered? They write a note, they give it to the court officer brings it out to the judge brings the attorneys in and says, we have a note from the jury. And when everybody in the courtroom, they bring in the court reporter. On the record, the judge will read what the note is. Then there is a discussion. How do we handle this? Right? Sometimes the discussion will take place off the record, but a lot of times it is on the record. Most of the times it is off the record, and then it is on the record with the outcome. A lot of times a note will resolve in a readback of testimony. Sometimes it is a readback of the jury instructions. And sometimes it's just a simple question or answer that the judge will answer if the parties agree. When the jury has a verdict, they send out another note, and the note says, we have a verdict. We have reached a verdict. Judge brings the attorneys in again. He brings in the court report. He says, we have another note. Now, the judge and the court officer probably know what the note is, but they don't tell us. And on the record, they will open up the note. The note will say, hey, we have a verdict. Okay, are we ready? All right, let's get the jurors in. It takes them a few minutes to get assembled. They bring the jurors in, and they will say, jurors, have you reached the verdict? The foreperson will rise and say, yes, we have. The judge will say, okay, what is your verdict? And they will read from the verdict sheet. Now, the verdict sheet is not something we've talked about. We did talk about the charges, which I've talked about repeatedly before. Just going back a little bit, before the end of the case, at some point there was a charge conference. Sometimes it's early on in the case, sometimes it's later in the case, but the charges are not necessarily agreed on by the attorneys. There is a conference that initially is held off the record, then then it's held on the record. If you disagree with the charges that are being read, whether there's a charge in there you don't want, or whether there is a charge in you want that is not being read, you note your objection, you put it on the record, and the purpose of that is to preserve the record for appeal in case things don't go your way. In connection with providing a request to charge, a verdict sheet is prepared. Right? This is done, again, before closings. You want to know what the charges are before your summations, and you want to know what the verdict sheet is going to read or how it's going to read before you sum up. And a lot of times the attorneys will actually refer to the verdict sheet in their summations, because you sort of want to lead the jurors into coming to the decision that you want them to make. So you go over the verdict sheet, you go over the charges, and hopefully they come out your way. So when the jury has a verdict, they read the questions off the verdict sheet. The judge will ask if it's unanimous or not, and then they will ask the losing party if they want to. Well, they technically ask both jurors, both sides, if they want to poll the jury, which means they ask each juror individually what their verdict was, or what their decision was, and they have to answer. Once the verdict is decided, there is a winner and there is a loser. Somebody is going home not happy. The person who is the loser and is not happy will make a motion to set aside the verdict as against the weight of the evidence. Again, now you're kind of less prepared because you don't know what the verdict is going to be. You don't know that you're going to lose going into this situation. So you're not necessarily going to have a memorandum of law. So what you should do is make a motion to set aside the verdict and ask the judge for permission to do so in writing, and generally for more time than you're allowed to under the law. I think the law requires 15 days. In New York, we usually ask for 30 to 60 days, or as much time as you can get, and the judge will usually grant that application. What we discussed here is the general anatomy of a trial. This is how a civil trial works in New York. The situation is different if you're in federal court. It's not much different. The jury selection process is different. The rules are a little different on how you do things and when you do things. But this is generally the anatomy of a trial. Criminal trials are different as well. But again, it's a similar format. The skills are always the same. If you found this information helpful, please hit like on the video, subscribe to the YouTube channel, and if you have any questions, leave them in the comments, or feel free to call me at any time. I am happy to help you, like the attorneys when I was starting out help me. The number is 1-855-PRizzuto, RIZZUTO. Give me a call. I'm happy to help you. And if you found this information helpful, like I said, subscribe to the channel. Check out my other videos, and I'll see you there.